You got grievances against everybody.
No, it's not.
She's done a fine job. She got you here.
I know.
She's protected every constitutional right that you have. You ought to be thanking her rather than criticizing or saying she didn't do something.
This courtroom hearing starts like many others, but within moments, it turns into something far more complicated. The defendant, Sebastian Phillips, walks in convinced that nearly everyone involved in his case has wronged him, from public defenders to social workers and even medical professionals. But as the judge begins listening to these claims, the conversation quickly shifts from legal arguments to something deeper. Questions about credibility, process, and whether the court needs to take an entirely different approach to understand what's really happening here. Now here's the key moment you need to watch closely. Instead of debating the charges directly, the judge makes a decision that could change the entire direction of the case, ordering a forensic evaluation to determine competency. That move alone can completely alter how the justice system handles what comes next. So as you watch this unfold, ask yourself, is this a defendant trying to expose serious problems, or is the court witnessing a situation where the legal process itself needs to pause and reassess? Let's break down exactly what happens next.
Would have had the police report.
Oh, okay. Well, I wasn't sure because she cited...
I know. That's why I'm correcting you.
Oh, okay.
Go ahead. Well, what's your next point?
Well, I'm just saying she cited information based on the police report. That's all I'm saying.
She cited information based upon what she may have known, but she may not have had that physical report.
I know. That's fine. But all I'm saying is it affected my ability to properly assess which direction I wanted to go personally for the matter.
What do you mean?
Because she said it was on Park Street. I looked up Park Street. It wasn't even...
So what does that mean? Why did that affect your ability to do anything?
It's
because
misdirection.
After the arraignment, this date would have been set.
I'm just saying it's a form of misdirection when you tell someone that a crime occurred at one point when it didn't actually occur. Once I found out that...
And so what prejudice has occurred to you?
I just believe it's abuse of discretion. And
abuse of what discretion?
To steer outcomes in their best interest.
To steer whose outcomes?
The fate of my judicial charge in their best interest.
In whose best interest?
Theirs, not mine.
Theirs being whom?
Public defender's office.
The public defenders, guess what? You and them are on the same side.
I'm not saying that.
So if it's steering it in that direction, you win.
I'm just saying human error.
Okay, they're human beings. That happens.
Yeah, but...
Okay, so what?
All I'm saying is... Okay.
What is your next point?
Okay, so CMH workers were not informed. I had to inform the CMH workers. I'm a client of CMH.
Yes, sir.
And I do receive Section 8, and I do believe that, they're trying to oust and discriminate minorities who are affiliated with Section 8 and CMH.
Who's trying to do that?
My worker, Steve.
Oh, at CMH?
Yes.
I don't have anything to do with CMH.
I know, but I wanted to know if I would lose my Section 8 and my Social Security if I was ever charged with a crime. I haven't been charged with a crime since I was 47.
I can't answer 18. That. I think typically, depending on the nature of the crime, because I do a lot of the work, you're not going to lose Section 8.
Okay.
You may have some issues with Section 8.
Yeah.
And I'm just telling you that based on my experience. Your individual case may be different where they may decide to take your Section 8. Yeah. So don't go saying Judge Simpson said this wasn't going to happen and violated some right. I'm just trying to instruct you that can happen, but it's rare.
Yeah, all I'm saying is that that information is pertinent to my choice of plea. So I'm saying if I knew I was gonna lose my Social Security or lose my Section 8, that would give me the decision to make, which would be in my best interest. And finally, I wanted to say that my Dr. Bright, who's my doctor, she stated that she was ordered to kill me, and I filled out a form with the Laura, Licensing and Regulatory Affairs. I have a copy of the order. I gave it to prosecution, and I was abducted out of the ER at the hospital, and I reported to the University of Michigan Police, and the governor also was informed, so she's aware what's going on.
Governor Whitner?
Yes.
Oh.
I caddied for her stepdad. I was his personal caddy. For her stepdad at Country Club of Lansing.
Yeah.
And also Justice Brennan Sr., just to let you know, before he passed away.
Cool.
Yeah, and I caddied in the LPGA for 3 years. So anyway, I just wanted to say that finally, CMH has resorted to consternation and contumacy involving the death threats. adulterating medications with opioids.
Ooh.
Pharmacy in conjunction with CMH.
Okay. Good.
And FDA MedWatch notification was notified. There's a procedure for that if it happens. So I believe they're trying to oust, avenge, and assassinate me. Based on the civic income, I can give you all the information. You can contact the governor's office too, because they know everything. And I know that I haven't been charged with a crime in years. And I just don't think that, it's something that is criminally intended or actually like occurred to the charge that you suggested in the form of a felony. I think that's overcharged. It's just my opinion.
Okay. So here's what I'm going to do. I'm going to order a forensic evaluation as requested. I've signed the order. I'll set a competency hearing in this matter for
March 19th.
March 19th, 2026, 9 a.m. Bond will continue.
So can I make the final request or statement? So you're saying that I can't request a motion to suppress and dismiss on this basis?
Do what?
Request a motion to suppress and dismiss the charges.
I don't know
on
what
these
that kind of motion is. If you're looking to suppress evidence, then maybe you need
not
to
necessarily
talk to your attorney about that.
Like immunity.
Immunity?
Yeah, from this charge, based on all that has occurred.
You want a motion for immunity?
Yeah.
Well, I don't know what that is, and I couldn't order that anyway.
I thought it was a legal term. I studied on it.
Well, it's a legal term, but you're using it incorrect.
Oh, okay.
And Your Honor, if I may, I did speak with Mr. Phillips last week, and
How'd that go?
I told him we went over options, and he was on board at the time with having an evaluation done.
Got it.
And I have been in contact with his CMH worker. They know that he had a hearing today as well. So,
all right.
That's only because she didn't agree with me.
Pardon?
She didn't agree with me.
Agree with you about what?
All the stuff I just told you.
I can see why.
Okay.
So here's what will happen is they're going to do the evaluation. We'll figure that out. We'll see in March and see where this case goes.
But she won't even tell me the outcomes of that. If I have an evaluation, what happens after that?
Well, it depends on what the evaluation says. There's no way for her to answer that.
Okay.
Yeah, I know.
sorry, I'm not a fortune teller, Your Honor.
Pardon?
I'm not a fortune teller. I can't tell the future.
It's civil procedures, legal procedure. That's all. She didn't cite the proper procedure once this forensic evaluation occurs and what will happen after that. What are my options? She didn't tell me any of that. And she didn't call me in about a whole week.
You got grievances against everybody.
No, it's not.
She's done a fine job. She got you here.
I know.
She's protected every constitutional right that you have. You ought to be thanking her rather than criticizing or saying she didn't do something.
No, I didn't mean
the
to
very
criticize.
fact you're standing here and like your liberty has not been taken and you've been allowed to say anything, you need to thank that young lady
I
standing
appreciate
next to
you.
you.
Thank you.
Thank you. Bond will continue.
What we just watched is a perfect example of how courtroom proceedings can shift direction when a judge senses that something deeper might be going on. Instead of immediately debating guilt or innocence, the judge made a procedural decision, ordering a forensic evaluation. In legal terms, that evaluation determines whether the defendant is competent to stand trial, meaning they fully understand the charges and can properly assist in their own defense. Throughout this hearing, Sebastian Phillips raised a wide range of concerns involving his public defender, housing assistance, medical treatment, and even government officials. But from the court's perspective, the priority is making sure the legal process remains fair and grounded in clear facts. That's why competency evaluations exist. They protect both the defendant's rights and the integrity of the court system. Now, the next step in this case will be that March competency hearing, where the results of that evaluation could determine whether the trial proceeds normally, requires additional support for the defendant, or takes an entirely different legal path. But here's the big question for you watching. Do you think the judge handled this situation the right way by focusing on evaluation first, or should the court have addressed the defendant's claims differently? If you found this case as fascinating as we did, make sure to hit that like button, share your thoughts down in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns just like this one.